Hello, everyone. Welcome to the Arbitration channel. We are here again with the Hard Talk. My name is Lauro Parenti. Arbitration channel is a think tank focused on alternative dispute resolution methods. We are sponsored by some of the most important arbitration players. Hard Talk is an arbitration channel project focused on spatial and dynamics debates with the great names. And Hard Talk is sponsored by Tosini Freire Advogados, a Brazilian expert, Simonagio Certeza Técnica, and Last Litigation Finance. And in the last 12 months, we reached more than 20,000 spectators. Today, we'll discuss pathological clauses with an international team of renowned professionals. Eliane Carvalho, partner of litigation arbitration at Machado Meyer Advogados. Fernando Marcondes, partner at MIMG Advogados, both in São Paulo. Gary Bourne, partner at Women Hale, and chair of International Arbitration Practice Group in London, and to be our moderator, Sofia Martins, partner at Miranda Law Firm in Lisbon. All of the speakers have extensive biography, and we make this available on the description of this video. And I ask everyone to subscribe our YouTube channel and follow us on social media. Let's go straight to the main subject of the event today, and I invite Sofia to start. Hello, Sofia. Thank you.
Hi, Lauro. Well, hello, everyone. It's great to be back on Hard Talks. Thank you all for taking the time to be with us today. And obviously, thank you, Lauro, and the organization for inviting me to moderate what I'm sure will be a fantastic panel. As Lauro mentioned, for those of you who may not know me, my name is Sofia Martins. I'm a Portuguese lawyer based in Lisbon, Portugal. And I head the dispute practice at Miranda Law Firm. The topic, sorry, there's something wrong with the sound? No, that's fine. The topic that we're going to discuss today is, in my opinion, a great one, and that will never be outdated. As we all know, arbitration clauses are commonly known as the midnight clauses. Sometimes clients don't even seek any specialized advice whatsoever when drafting arbitration clauses. Sometimes our colleagues from other areas of the law leave the arbitration clause for the last minute, hence the name midnight clause, just before the closing, with results that are often far from satisfactory. And many times they just copy-paste clauses from other contracts, or sometimes they just think there's really nothing special about the arbitration agreement. And they don't even run them by arbitration specialists. But this could not be farther from the truth. These clauses do cause a lot of problems. And I love a quote from Rusty Park, who once said that the cardinal rule of drafting international arbitration agreements is to avoid the type of ambiguity and equivocation that will later delight a party wishing to drag its feet. As we all unfortunately know too well, the poorly drafted clause can lead to extreme delay, higher costs to proceedings, and in some cases it can even render recourse to arbitration impossible. And to discuss this never-ending topic, as Lauro just mentioned in the brief introduction, we have three amazing people. We have Eliane, who's already been introduced. As Lauro mentioned, she's a partner at Machado Meyer, based in São Paulo. She has over 20 years experience. She's also one of the current representatives of Brazil with the ICC Accord, and she's recognized by the main international rankings such as Chambers, Leaders League, Who's Who's, Latin Lawyer, among others. We also have Fernando Marcondes, a leading partner, as Laura mentioned, at MAMG Advogados, also based in São Paulo. Besides this, he also sits as arbitrator and on dispute boards in complex construction and infrastructure cases. He's also the Brazilian country representative on the dispute board, Dispute Resolution Board Foundation, and the president of the Brazilian Clube Espanhol, chapter of the Clube Espanhol del Arbitraje, which I'm also a member of together with him. He is also once again recognized by the main international rankings that I mentioned for Eliane, and has recently actually been awarded the Lexology Client's Choice Award as the exclusive Brazilian winner in the category of construction lawyer, which is an area where we all know there are lots of arbitrations and obviously lots of problems with pathological clauses. And then last but not least, certainly not least, we have the pleasure of having us today, Gary Bourne. While he is most certainly known to you all, just a few pointers. Gary is the chair of the International Arbitration Practice Group at Wilmot-Cutter, Pickering, Hale and Dorr, as Lauro mentioned. And he's also one of the world's preeminent authorities in international commercial arbitration. If you don't have his book called International Commercial Arbitration, you should. And the third edition has just come out, so don't waste any time and get it if you don't have it yet. Gary has served in an impressive number of arbitrations as counsel, 675, over 675, including several of the largest disputes in ICC and in ad hoc history. And he's also sat as arbitrator in over 250 institutional and ad hoc arbitrations. I could go on and on, but I will just mention that he's also obviously a professor at many universities, such as St. Gallen in Switzerland, in Tsinghua University and Beijing, and teaches regularly in a number of other schools. And he's also president of the SIAC, the Singapore International Arbitration Court of Arbitration, and it will be certainly interesting to have his views from the institution's point of view and on some of the clauses that we are going to look at today. As is obvious, he's been recognized many times by the most important legal directories. And just to give you some examples, he has received the Global Arbitration Review Inaugural Advocate of the Year Award, Client Choice for the Best International Arbitration Practitioner that's in the world. And I will stop here. Enough about introductions, and let's move on to our topics. Now, the first topic that we'd like to discuss today it relates to one of the issues that we see many times in which basically is the faulty drafting of arbitration agreements that then leads to a doubt as to what the parties actually wanted to foresee as the dispute resolution mechanism. And on the screen, you will see three examples that we've selected and that we hope to prompt the discussion. So as you see in the first clause, we have any dispute of whatever nature related to the agreement. But then we have some doubts that I'm sure our panel will address. And basically the issue here, and without further ado, I would turn the floor to Eliane to comment first on these three examples. Eliane, what can you tell us about what the parties actually wanted when they drafted these clauses and others similar to these clauses that we often encounter in our professional lives?
Thank you, Sofia, for this introduction, and also thank you, Lauro, for this invitation. Just a small remark before discussing our clauses today. I want to be frank with you, Lauro, and say to you that 5 minutes after I received the invitation, of course, I was honored to be invited to be here, but then I started hating you because I thought, my God, are you crazy? Have you just accept to be in a panel with Gary Bourne, the one that wrote those three big little books, those blue books that you have in your table? And then I said, I thought it will be really, really a hard talk for you. But again, I'm honored to be here. I just hope that I will reborn to be as talented as all the panelists here today. Thank you again for the invitation, and then I will pass to the comments in relation to those clauses that Sofia mentioned here. Can you put on the screen again the clauses for us to discuss it? I think it will be better for you to follow my comments here. So I'll start talking about this first clause here. As you can see, this clause is not too thick. It is really clear here that the intention of the parties to use arbitration as the dispute resolution method. The clause contains a light wording when it mentions may be referred to arbitration instead of using hard word like must be referred to arbitration or shall be referred to arbitration. So doubts could arise as to whether the submission of a claim to arbitration is in fact mandatory. However, it seems to me, and of course, I would like to hear my colleagues here, that this light wording will not prevent the commencement of the arbitration. Another problem that we can see here is in relation to the seat of arbitration. As you can see, it mentions that the arbitration will be in the US, but it does not mention the city. This, of course, is a problem because the seat of arbitration is an important issue, and we are going to discuss this in other topics later today. But this problem here can be easily cured. Parties can suggest a seat when filing for arbitration, and if there is no agreement between the parties about the seat of arbitration, the institution or even the arbitral tribunal can fix it. Most of the institutional arbitration rules provides that the place of arbitration can be fixed by the institution. As such provision you can see, for example, in Article 18.1 of the ICC rules. And the last problem that I see in this clause is that it mentions the rules of conciliation and arbitration of the ICC, and we all know that there is no such rules of conciliation before the ICC. The ICC has arbitration rules and mediation rules, but it has no specific conciliation rules. However, again, this reference is curable and should not raise further doubts that arbitration should be handled by the ICC. Those were my comments for this first clause, and then I can say some more words in relation to the other two clauses, because in my opinion, those the second and the third clause, they have important problems. The second one, it seems to me that this clause has a bipolar disorder. Instead of making reference to an arbitral institution, the parties have mentioned that a state court will have jurisdiction to decide upon the case, even though the clause makes also reference to arbitration. And then the clause used the word but, which causes further problem because it gives the impression that the parties wanted arbitration to be applicable in certain cases, but maybe a litigation in others cases without having specified how the arbitration would be conducted and under which rules. And then I just searched this Tribunal de la Seine, and it seems to me, I don't know if, and I think my colleagues here have more information about that. It seems to me that this Tribunal de la Seine does not exist anymore. So in this clause, it seems to me that it is really difficult to perceive that the will of the parties, that they really intended to arbitrate. If this clause is not accompanied by other documents that attest that the parties have actually intended to arbitrate, this is a clause that might be or probably will be invalidated by the courts. And then some comments about the last clause. The last clause is again a really sick clause. This clause was discussed here in Brazil, and I have the number of the decision if someone is interested in, but it was invalidated here in Brazil before the State Court of Appeal in Rio de Janeiro. And the court invalidated the clause because the clause wasn't inserted in a contract. It was just an invoice in which it wasn't not even possible to identify the parties. It made reference to the arbitral justice and to a non-existing arbitration institution, First Arbitral Court of Passo Fundo, confusing state court with arbitral institution, and then it was considered a null and void clause here in Brazil. Just a final remark about that. It mentions that the Brazilian Arbitration Act is from 1996, and the Brazilian Arbitration Act is from 1996, and the clause mentions 1997. So, Sofia, those were my comments in relation to those problematic clauses here, and I'll leave the floor to Fernando, and I think that he can add a lot more about that. Thank you.
No sound. You're muted.
Some comments to make on the Passo Fundo decision, and then after that, I would like if Gary could offer some comments, especially on the first clause, with all the omissions and no reference to institutional rules. How could we deal with that? So, Fernando, over to you with Passo Fundo.
Yes, I don't know Passo Fundo personally, but I have some comments about it. It's very interesting that the first court of arbitration of Passo Fundo actually existed in the past. They used it to be a private company, started in 2002. I made a research in Google to know about that. But according to the information available in the internet, it's not able to work anymore. Formally, they still exist, but there is no news about any activity in arbitration. And actually, in the first years of the arbitration law was issued here in Brazil, we saw a great number of adventurers trying to make some profit, creating a confusion between state courts and fake arbitral institutions. So it used to be common until 2004, 2005, to find names like Superior Court of Arbitration, Federal Court of Arbitration, Supreme Court of Arbitration. They even used it to display a coat of arms of the Brazilian Republic, which is forbidden, only to create a fake solemnity and to deceive people. Fortunately, it's far in the past. The Brazilian Bar Association has defeated these guys. But the clause is curious anyway. So I think this it's a point of interest of this, maybe a curiosity about this clause specific. Do you want to I comment the other ones, or pass to Gary?
No, I can. Maybe we can switch over to Gary. Gary, if you were the arbitrator with these three clauses, would you consider that the parties did elect to arbitrate, or maybe not?
Why don't we, in order to answer that question, why don't we put the clauses back on the screen so that we can look at them? While we're getting them up on the screen, it's helpful just by way of background to remember where the name, the title, pathological clauses comes from. It was an invention 50 years or so ago by Frederick Eisemann, one of the early secretary generals of the ICC, one of whose clauses is at issue here. He wrote a law review article about pathological clauses and drew on his experience at the ICC in seeing and administering arbitrations under all manner of clauses. He said he wanted to create a dark museum of monstrosities. And he listed in his law review article a number of those monsters. In my own view, though, I think Eisemann was a little bit too negative, a little bit too pessimistic. I don't think that we should look at arbitration clauses, even if they're not perfectly drafted, as monstrosities or relegate them to some dark museum. I think instead we should have a more caring attitude. We ought to view them as convalescing patients who need our help, need our remedial efforts, and not out of a spirit just of generosity, but instead because that's consistent with commercial parties' objectives. The reason parties put a midnight clause into the contract is because they want an efficient and expeditious and expert and even-handed way to resolve their disputes. That's especially true, as we all know, in international matters where parties desire the neutrality of an international tribunal as opposed to national courts. Inevitably, the national courts of one or the other, or perhaps both parties. And therefore, what many national courts have done, and I entirely applaud these efforts, is to not consign pathological clauses, even clauses like what we see on the current slide, to some museum of invalid midnight efforts which have failed, but instead tried to make commercial sense out of them. It sometimes requires giving effect to the party's unstated intentions. Sometimes it requires ignoring or striking out mistaken references. But all of that is entirely justifiable if it is aimed at achieving the party's true commercial intentions. And I think that, in fact, can be done with some effort, perhaps, but with each one of these clauses. The first clause, let's take some of the various defects that it has. The reference to the non-existent rules of conciliation and arbitration, I think, can be repaired. If a party refers inaccurately to the rules of arbitration of the ICC, one nonetheless is able, relatively easy, if what they've done is refer disputes to arbitration and referred to the ICC, relatively easily interpret that mistaken reference as a reference to what we all know, the ICC rules of arbitration. The clause also, as has been pointed out, doesn't specify very clearly an arbitral seat. It discusses an arbitration taking place in the US rather than saying the seat or the place of arbitration shall be New York. Nonetheless, although law professors might come up with an esoteric interpretation that means only the hearing shall be conducted in the US and the parties haven't selected the seat, the obvious answer is that in saying where the arbitration would take place, they intended to select the seat. They haven't, of course. The United States, like Brazil, is a big country, and there are lots of places in the United States which might be the seat. But as has also been pointed out, the ICC rules have a ready default mechanism for specifying the seat somewhere in the US, even if the parties haven't done so themselves. And finally, the reference to may instead of shall has been interpreted by many national courts, virtually all national courts, as a proper arbitration agreement. When it provides that disputes may be referred to arbitration, it recognizes that parties may choose instead to settle their dispute. Nobody is required to start an arbitration. However, once one party does start an arbitration, uses its freedom under the clause to do so, then the other party is obligated impliedly to go forward and participate in that arbitration. And so therefore, I think the first clause, although it probably deserves a C- or D+ on a law school exam, is nonetheless a perfectly valid arbitration agreement. I'd also say, perhaps a little surprisingly, the same thing for the second clause. The parties pretty clearly intended to refer disputes to arbitration, and the reference to litigation, many national courts have done that, would be a choice of forum provision for arbitration-related litigation. And that's the place where annulment applications, where emergency provisional measures in aid of arbitration would be sought. Now, the parties, just as they didn't have a very good arbitration clause, didn't apparently have a very good choice of forum clause, because the Tribunal de Lausanne doesn't exist. But I think we can figure out what they must have been intending to refer to by consulting our French geographical atlas, and the party's choice of forum would therefore be capable of rectification. Similarly, in choosing the courts where proceedings related to the arbitration would be held, the parties also impliedly selected the arbitral seat. The seat of the arbitration would likely also be in the place where related litigation would occur. And finally, with respect to the final clause, the mistake with respect to the year of the Brazilian legislation, I think, is one that can easily be rectified. I sometimes get confused about when the Federal Arbitration Act in the United States or the English Arbitration Act here in London was enacted, but that doesn't make my arbitration agreements invalid. The fact that the arbitral institution formerly existed but no longer does is a bigger problem, but it also can be overcome. The parties intended a form of institutional arbitration. That institution no longer exists, but their underlying desire to resolve their disputes by arbitration pursuant to the Brazilian Arbitration Act allows one either to conduct an ad hoc arbitration or alternatively to select a different arbitral institution, perhaps one of the better known Brazilian arbitral institutions. I recognize that the Brazilian courts reached a different conclusion, but I'm confident in the future that they'll find a way to heal this admittedly somewhat ill example of an arbitration clause.
The point that you just made is very important. When we look at these clauses, we really have to see what the underlying will of the parties was. But at the same time, if we have a party wishing to drag their feet, we're in for a wild run discussing procedural issues rather than getting to the discussion on the merits. But I would tend to agree that most of these defects would be curable by way of some form of antibiotic. Now, Gary, I would like to stick with you for maybe our second group of clauses. Another thing that we often see is people who actually write too much, thinking that they're helping to refine the scope of disputes. But my question to you is, and I would ask Fernando if he could project this second group of clauses, are people actually helping when they draft this sort of wording in order to try to define the scope of disputes that are actually supposed to be subject to arbitration?
So thanks very much, and let's keep those two clauses on. Many national courts interpret arbitration clauses expansively. The general notion, one sees it in cases like Fiona Trust in the United Kingdom, Mitsubishi Motors in the United States, similar sorts of decisions in a number of civil law jurisdictions, interpret clauses to provide for what courts call one-stop shopping. Parties don't particularly want to have their disputes resolved in multiple different forums, creates additional expense, possibility of inconsistent decisions by different tribunals, courts, arbitral tribunals, perhaps other authorities. And therefore, arbitration clauses are interpreted expansively. Nonetheless, my own view is that it is appropriate to define the scope of disputes which will be resolved by arbitration expansively, just to give added impetus to the one-stop shopping concept. These clauses are not necessarily the way one would draft a clause. I think if one looks to the formulations in institutions, model arbitration clauses, those are sometimes preferable. In general, my advice, going back to what Sofia said about Rusty Park's admonition, my advice about drafting arbitration clauses is even shorter. It's KISS, K-I-S-S. Keep it simple, stupid. The simplest way to keep an arbitration clause simple is to use an arbitral institution's model clause. They're available on the institution's websites. They've been tried and tested. They've been drafted and redrafted for literally generations in the case of the ICC. And my general advice, therefore, absent exceptional circumstances, is don't deviate from that. If you do, you're walking into uncharted territory, and people will inevitably ask, well, if they changed the clause, they must have meant something different from what the model clause says. What did they really mean? And it introduces exactly the types of procedural games playing that Sofia cautioned us to avoid. These particular clauses, I don't think are very desirable clauses. The first clause I think there's more problems with it than just the scope of the clause. The scope of the clause, all disputes arising out of the performance of the contract and during the term of the contract, isn't ideal. does that, for example, extend to things like validity of the contract itself, existence of the contract? Arguably not, because of the way that it is drafted. I think most courts would nonetheless interpret this provision expansively to reach issues of existence, validity, legality of the contract. But there's certainly an argument that it only applies to issues of performance during the term of the contract, not to either earlier or later issues. I think the bigger problem with that clause is shall be submitted to an arbitral tribunal. No reference to arbitral seat, arguably a blank clause. If there's no seat and no institutional rules, then if the parties don't agree on who the tribunal is, how do you constitute a tribunal? It certainly creates practical difficulties. A Hong Kong court in a case called Lucky-Goldstar, which I actually think is very well reasoned, interpreted a clause quite similar to this as giving the claimant the option to select the arbitral seat. Once selected by the claimant, the respondent was obliged, if we could stay back on the first.
Yeah. The topic too. We had a problem with
in any event. In any event, and I'll just wrap up here on the first clause. In any event, without a reference to either institutional rules or an arbitral seat, a clause is arguably a so-called blank clause, therefore being incapable of being performed because you don't know where to go to have a court select the arbitrators if the parties don't agree. You don't have an arbitral institution to do it for the parties, and therefore, arguably, the clause is invalid. The Hong Kong court quite creatively interpreted that sort of clause as giving the claimant the option to choose the arbitral seat. Once that is done, you then have a court in the arbitral seat, which is the ultimate default mechanism, can select an arbitrator in the absence of agreement by the parties. I think that, although I termed it creative, is an entirely appropriate way to give effect to the parties' predominant intention to resolve their disputes by arbitration.
Fernando, maybe I would thank you so much, Gary. Fernando, given your extensive experience in construction cases, and knowing, as we all know, that it's very frequent in construction contracts to have a separation between certain disputes which should be resolved by arbitration, whereas others should be resolved, for instance, by dispute boards or other sorts of mechanisms. Maybe if you could give us your comment on the second clause and or views on how best to actually define the scope so as to avoid doubts and problems when proceeding to a dispute.
Sure. But I'd like to comment to the about this blank clause, the first blank clause. Just to people that are not from Brazil, here in Brazil, in the arbitration law, we have the provision of the possibility to go to the court to ask for a judge to decide what is the tribunal, how you have to choose the arbitrators and everything when you have a clause like this. So here we have this remedy. Of course, parties are trying to avoid the courts, but they have to go to the courts to start the arbitration. It's not the best way to solve the problem, but it's the way that we have here granted for the arbitration law. Well, talking about the second one, and then this solution of a court suit is served to solve the problem of the passo fundo clause too, because if you don't have the institution anymore, you can go to, and part doesn't reach the agreement to choose the new court, you can go to the new institution, you can go to courts to decide what is the new institution to proceed the arbitration. About this second one, I think that when you say if you have to go to conciliation, it's not mandatory. We have to stimulate initiatives of the parties to try to avoid the dispute, but we also have to understand that it cannot be mandatory, because sometimes or many times parties used to invoke this multi-tiered clauses just to avoid to initiate the dispute, to initiate the arbitration. So it's to be a good mechanism, not an obstacle to start the dispute, the arbitration. We have, for instance, when you have the FIDIC contracts that are used by international construction relationships, we have there the dispute board, and then after the dispute board, the decision of the dispute board, we have a 28 days period of amicable composition, but it's not mandatory. And in the same time, this 28 days, you have to start the arbitration. So the idea here in FIDIC is conciliation is not mandatory. And I think that this is the main idea, although we have to stimulate alternative ways to solve the dispute, the auto-composition, but we have also to grant the parties to go to arbitration with no obstacles that can send this start of the dispute for the eternity.
Thanks. I'm sure we'll be able to touch more upon that when we come to the topic on multi-tiered clauses. Eliane, I don't know if there's anything you want to add or still on this second topic on the definition of the scope.
Yes, just a small remark about these multi-tiered arbitration clauses. In this case, in the second clause here, it's really poorly written. This is my opinion. Even though there has been a lot of cases where vague or unclear pre-arbitral steps have been put aside in order to confirm arbitration was regularly filed. We have here in Brazil, before the courts of Paraná, a very bad decision about that, in which the award was declared null and void because the parties didn't comply with the pre-arbitral steps. So this is something that we should worry about when we are drafting a clause. But again, I'm sure that we are going to discuss this deeply in the other topic.
Yeah, I would just add that my major concern with the second clause is how would one elect which are the disputes that may be resolved by conciliation? And that's where I think a party wishing to drag their feet would most certainly be able to drag their feet. But we'll talk more about multi-tiered dispute clauses later on. So maybe I'd move on to the third topic. And this time I would start with you, Fernando. Another pathology that is common and that we've already touched upon when looking at some of the other clauses relates to either the choice of seat and or the choice of the arbitral institution. And in particular, the seat, for me at least, is very concerning because if you don't even have the seat, you can go to the state court of a given country, but the actual jurisdiction of that state court to decide the matter may also be disputed. So when no seat is there and no institutional rules or non-existing institutional rules are referred, can really constitute a problem. So Fernando, if you could have a look at these examples that we have now on the screen, and we'd kick off with you and then see if Gary and Eliane want to add something.
Sure.
Yep.
Yep. I think that this first clause, the problem, the pathology here is that there is no such institution. Is that right? Arbitration Center of European Countries. I searched in the internet. I didn't find this institution. So I think that this is the problem here. Nevertheless, the important point here is that the parties elected arbitration as the way to solve their disputes, as Gary was saying before. And if there is something in the clause that points to arbitration, we must go to arbitration. This is the pattern in lots of jurisdictions. And I'm not talking only about arbitration, arbitral decisions, but also about state court decisions. If parties are not able to reach an agreement in order to choose an institution and the rules and the way to appoint arbitrators, so the party interested in start arbitration can notify the other party, start an ad hoc arbitration under the PCA or UNCITRAL rules, for instance, call the Secretary General of PCA as appointing authority, and then proceed with the arbitration. I think we have the way to make this clause work. I would like to hear Gary about this.
Yeah,
No,
I can add. If I can add, this one is actually a real case. It pertains to a case, Control Screening LLC versus Technological Application and Production. And basically, one of the parties initiated arbitration in Belgium, and the other party requested for an order in New Jersey to compel the arbitration to take place in New Jersey. And this was a successful request in New Jersey because the American court in New Jersey gave emphasis to the part of the clause that says the suing party's country ignoring the rest, and notably the reference to Europe. So, but there was a dispute, one in the United States and one in Belgium.
Interesting.
Just picking up very quickly, I agree entirely with what Fernando said. The basic object here should be to give effect to the party's predominant intention, that intention being to resolve their disputes by arbitration. This is not the kind of clause that anybody should draft. It is the kind of clause that is almost certain to create procedural difficulties, but nonetheless, one can give effect to it along the lines of how Fernando outlined. U.S. courts do have an unusual approach, I think a largely idiosyncratic approach towards ordering arbitrations in cases where the seat is not clearly specified. U.S. courts will, if the respondent is subject to jurisdiction in the United States, compel arbitration in the United States. It's a view that is quite arguably contrary to the New York Convention. It's not a desirable statutory approach, and it's one that parties from other jurisdictions should be mindful of. My own take on this clause is that, properly interpreted, it should be a reference to institutional arbitration. There's a reference to both an international arbitration center, not a clear reference because it then speaks of European countries. That's either a non-existent institution or it's a sort of open category. Figure out which of Belgian, French, German, Swiss arbitral institutions ought to administer this case. But it is, when you look at the final clause referring to the rules of the center, I think it is pretty clearly a choice of institutional as opposed to ad hoc arbitration. I therefore think ultimately, and it might require a court, but it could also be an arbitral institution. Ultimately, one needs to choose an arbitral institution in one of the 28 or so European countries. I think, again, the approach adopted by the Hong Kong court in the Lucky-Goldstar case, giving the claimant the option of selecting the arbitral institution, is probably the least bad solution. It allows the arbitral process to go forward without judicial intervention, which has benefits of cost and efficiency. I think an interesting question would be if one submitted a request for arbitration under, for example, the ICC rules, would the ICC administer that case? Speaking for the Singapore International Arbitration Center, I think it's highly likely that SIC, would, if the reference were instead to Asian or to international institutions, would administer a case in those circumstances. Obviously, it's a poorly drafted, undesirable clause. Equally obviously, we should try to give effect to the party's basic desire to arbitrate.
What about the other clauses? I don't know, Fernando, if you wanted to add any comment on the other examples before passing the floor to Gary and Eliane for comments.
Yes, I have. This clause. They said here that the disputes in connection with the contract shall be settled by the Arbitration Committee at Singapore under the rules of the International Chamber of Commerce. This kind of mistake used to be very common here, but I have to say that I haven't seen a clause like this in the last years. Maybe parties are understanding better. I remember one case that took place here in Brazil at CAMARB, was an institution from Minas Gerais, one of the good arbitration institutions we have here. The clause was exactly like this one. It provides that disputes should be settled by CAMARB under ICC rules. Well, CAMARB said that it was impossible to apply ICC rules unless you are ICC. How could CAMARB offer scrutiny, for instance, if there is no such structure in the institution? Among other things too. The solution appointed was to go to ICC, but the claimant could not afford it. It happened before we have the facility of remote proceedings that are available now, and we didn't have the ICC office in Brazil at that time. So it was necessary to go to Paris to the hearings, for instance. And the fees at ICC were so high at that time. And more, in Brazil, you pay 40% of taxes to send money overseas. So the expenses were too high, and it was charged in 40% now. I'm not sure about the end of the story, but if I'm not wrong, the claimant tried to discuss the case before a court, but his claim was rejected because the lack of jurisdiction of the state court. And as far as I know, he didn't have a solution for this case.
Do you want to comment on the other two before moving to Gary and Eliane?
Yes, I can. Sure.
Or we could move on. You tell me.
If you have something to say right now, Gary and Eliane, please go ahead. Because we have many clauses here, so many.
Yeah, we still have many of them. So I don't know, Gary, Eliane, would you like to comment on any of the other examples that we see here? Singapore is your place, Gary. So if you have any comment on the second one.
Just very quickly, because I know we're running short on time. On the second clause, many institutions, SIC included, will administer arbitrations under other institutions' rules. The SIC has administered arbitrations applying the ICC rules and fulfilling the functions of the ICC with respect to setting in advance on costs, with respect to appointing and removing arbitrators, with respect to scrutinizing the award. I should underscore that the ICC does not like that much, but institutions ultimately have an obligation to give effect to the parties' agreement, to their intentions. I don't recommend in the slightest a kind of hybrid clause like this, where one institution administers another institution's rules, but ultimately arbitration is a creature of consent, of contract, and if that's what the parties agree, then my own view is that institutions both can and should give effect to that agreement.
Eliane, I don't know if you have any comments. I would maybe offer a comment just on example number 3, which I find quite interesting. It's actually a Portuguese clause from a Portuguese contract, and it basically sets the seat in Paris, which would imply that the French Arbitration Act would be the applicable law to the arbitration. But then it says in number 6 of the same clause that the Portuguese Arbitration Act will apply. So we have a bipolar clause here as well, which will lead to many problems. But Eliane, if you want to comment either on this one or on the last one, and then we could move topic.
Sure. Just one small comment in relation to the second clause here. If I'm not wrong, this is an arbitration clause in the famous case HKL Group versus Rizq, and where the parties made reference to this non-existing arbitral institution, the arbitration committee at Singapore, and to ICC. And in this case, the Singapore courts confirmed the validity of the clause because it was clear that the parties intended to arbitrate. And then the court ordered the parties to agree to an existent arbitration institution. They could try to use SIACI or other institution, and this other institution would use ICC rules. I don't know if, and maybe Gary could correct me if I'm wrong, but it seems to me that this arbitration clause refers to the case that I mentioned. Sorry.
No, I think that's correct. Singapore courts have, as I alluded to previously, upheld these kinds of hybrid clauses in a number of cases. I think the leading decision is a case called Insignia Technology. My own interpretation of that clause would be that the mistaken reference to arbitration committee or arbitration chamber in Singapore ought to be interpreted as a reference to SIIC. There's only one arbitral institution in Singapore that would decide these kinds of disputes, and the party's mistaken language, I think, could be properly interpreted as intended as a reference to SIIC. But there's certainly room for debate about that.
Yes, and then in relation to the other clause, as they were referring to the former Portuguese Act of Arbitration, I had a question for you, Sofia. Can an arbitral tribunal infer that the parties meant to apply Portuguese law by referring to the Portuguese Arbitration Act in this case?
It's a bit tricky. I think both positions can be sustained. One thing that I'm sure is that if the seat is in Paris and there appears to be an express reference to the city of Paris as the seat for arbitration, most surely the Portuguese Arbitration Act would not apply to, for example, a setting aside action. If this can be interpreted as being a reference to the applicable Portuguese law, a substantive law, very, 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 very tricky in my view. If I were to try to salvage this clause, I would most probably disregard number 6, because it basically says in all other aspects not regulated, then law 3186 would apply. And I would sustain that the reference to Paris would determine the lex arbitri for this case, and as such, the supplementary reference for everything else not considered to the Portuguese Arbitration Act would basically not have any room to be applied in the specific case. I think that would be my best take on this clause.
If I could just say one word about that clause as well, it raises the very pathological example of agreeing to a foreign procedural law. You seek the arbitration in one place, but you subject it to the procedural law of a different jurisdiction. Arguably, the New York Convention contemplates that in Article 5.1e when it refers to an award being annulled in the place where it was made or under the law of which it was made. The sort of one fundamental rule alongside KISS, K-I-A-S-S, is never agree to foreign procedural law, because it opens the door to countless procedural confusions. In particular, where do you seek to annul the award? In arbitral seat or in the place whose procedural law was chosen? Where do you challenge arbitrators? What rules of impartiality and independence apply to the arbitral tribunal? You can well imagine competing annulment applications in different jurisdictions, and although law professors can come up with even more creative procedural difficulties in those kinds of cases, it's the last thing in the world which any commercial party would want.
Totally agreed. Well, I think we'd better move on to the last topic. We just have one clause here. I think the main issue in the last clause is this an actual choice of institution, or actually we just referring to an appointing authority? I don't know, Fernando, you wanted to add something?
Yes, I'd like to say something about the last one, Sophie, if you allow me, because
Please, sure.
I have an interesting case to share. Apparently, the idea here is to have a previous period of conciliation or mediation, maybe. But under what rules? And worst, the clause suggests that the arbitrators will play the role of conciliators or mediators. People say everywhere, your mediator cannot be your arbitrator. I had a case in Chile a few years ago. My client told me that he had a conversation with the chairman of the opposite party. And they decided to suspend the arbitration and try a mediation. I said, oh, this is good, so civilized, let's do it. Then he said, we also decided that the mediator will be the chairman of the arbitral tribunal. I said, uh-oh, this is not good. Then I wrote a quick legal opinion to my client, quoting a lot of international authors, saying that, one, your mediation will fail because no one will be confident to tell its weakness to the mediator. Or two, you will jeopardize your case, because if mediation fails, the arbitrator will know about your weakness and maybe he will create a bias. Well, they insisted to do that. We went to Santiago and spent an entire week there. And the outcome was that now I know much more about Chilean wines than before. Actually, the mediator never put parties together in the same room and spent the days interviewing parties about its points. That means who was there was not the mediator, but the arbitrator, trying to improve his own knowledge about the case. In the last day, he asked for a number to both parties. We put together, we put a number in a paper. He looked to both numbers and said, the numbers are too far away from each other. I think the mediation has failed. Let's proceed with the arbitration. So it's something sick. It's very dangerous to provide that a mediator and arbitrator will be the same person. So I think this is a very trouble clause.
Thank you so much, Fernando, for that comment. Well, maybe with that, and unless anyone wants to add anything on this specific clause, I would move on to topic number 4, which relates basically to the choice and method of appointment of arbitrators. Many times, parties want to define criteria for selecting the prospective arbitrators at a stage when the contract is obviously being drafted, when the arbitration agreement is being drafted. In my personal opinion, this is not always a very wise choice. And Eliane, maybe turning over to you, what problems come to mind with the examples that we can see on the screen?
Thank you, Sophia. This first one is a really interesting one. When I was preparing for this hard talk here, I read an article wrote by John Townsend, and he mentioned 7 sins that plague arbitration clause. And one of the sins that he mentioned is the omission. When the parties fail to specify important things in an arbitration clause. And then here we have the opposite sin of the omission, which is the over-specificity. Rather than providing insufficient detail, the drafter of the clause provides too much, right? When the arbitration clause is like this one, it will create layers of difficulties to appoint arbitrator. This is what I can see here. It is not a problem, I mean, to provide some characteristic for the arbitrator. such as knowledge of specific language or certain years of practice. But you must be careful when you put a lot of specification like in this one, because maybe you will have trouble to find the guy to be the arbitrator here. And again, as Gary mentioned in his comments about other clauses, if you have doubts, use the suggestions of the arbitral institutions, because those clauses are simple and they were tested by courts and other arbitral tribunals. Those were my comments for this, the first clause here. In relation to the second one, in this clause, the parties made reference to arbitral institution as an arbitrator. The reference to, and another problem here, the reference to submitted in the first instance adds another layer of confusion to this clause, because since we don't have appeal in arbitration, so this expression submitted in first instance could create a problem here as well. So in this clause, even though the intention to use arbitration is clear, and that the parties wanted to use an arbitral institution, they were not specific in relation to which institution they wanted to use. There is just a vague reference to a well-known chamber of commerce. And then, as the drafter did not choose the institution, the parties will have to try to reach an agreement about that. And reaching an agreement about this when the dispute arises could be a nightmare for the parties. Because if they are disputing, it will be really difficult to agree on that. And then if we were here in Brazil, the lawyers would try to exchange notice to try to agree. In this provision, we have a provision in the Brazilian Arbitration Act in Article 7. And if they cannot agree on that, then the lawyer will have to file a lawsuit to try to compel arbitration according to Section 7 of the Brazilian Arbitration Act. I don't know if my colleagues, if they want to comment this first one, and then we can move to the second. Those were my comments about in relation to this clause here.
Yeah, Gary, I don't know if do you have any further comments on the third one, or should I move on to Gary and Fernando?
Sorry.
Well, I'm sure Gary has comments on the third one because it's in his book, the one that I told you. So I'm sure he'll have some comments on the third one.
Just very briefly, I agree entirely with what Eliane said with respect to the first clause. Of course, when you have a clause like this, it not only leads to difficulties in constituting the tribunal, how do you find a person with all those various attributes, but also leads to potential challenges to the award. One of the grounds for non-recognition of an award, also for annulment under the model law, is a failure to constitute the tribunal in accordance with the parties' agreement. And here, if the arbitrator doesn't speak Chinese, as well as one would hope, doesn't have the level of familiarity with Middle Eastern construction contracts that one claims is necessary, there would be an obvious invitation to either annulment or to non-recognition. Just very briefly, with respect to the final clause, it's a clause that actually arose, I believe it was in a French case in which the Director General of WHO declined, in fact, to do what the clause invited him to do, or her to do, namely to appoint an arbitrator. If you are going to have a creative choice of an appointing authority in your arbitration agreement, you need to make absolutely sure that choice, the person, the institution that you select, is going to be willing to carry out the task that it is asked to do. If the appointing authority refuses to act, then you have a question as to whether you still have a valid arbitration agreement if you don't have the appointing authority that the parties agreed on. does the clause become invalid? My own view, consistent with what I've previously said in earlier remarks, is the clause would remain valid, and you blue pencil out the defective reference and either replace it with your typical default solution, namely national courts in the arbitral seat, if there is one, or failing that, an arbitral institution, if one can conclude that the parties impliedly intended some other arbitral institution to act in a default capacity. It's probably difficult in this particular case, but further investigation might reveal from negotiating history or something of the like some alternative intention.
Just before asking Fernando if he has any comments to add, apparently in this case, the ICC actually appointed the arbitrator following the refusal from the Director General of the World Health Organization. And the ICC's appointment was upheld by the Swiss Federal Tribunal in a judgment dated 16 April 1984. So that's how this case was solved eventually by the Swiss Federal Tribunal. Fernando, would you like to add some comments on this particular topic?
Only the first clause. Maybe they forgot to decide the color of the eyes of the arbitrator, because it's so specific. Maybe there is one or two people in the world that can reach this specifications.
Yes, I think that's a very pertinent comment, because parties sometimes try to give such characteristics that they don't realize that they're actually narrowing the pool of prospective arbitrators. And as one of you said, I'm sorry, I don't remember which, if we trust the institutions, we know that good institutions will typically select appropriate arbitrators. So it's better to go with institutional arbitration and rely on the competence of those arbitral institutions to select the appropriate arbitrators. Well, but let's move on then to topic number 5, which is basically a field day for pathologies. We're using Gary's image, slight ailments, or sometimes not so slight, that need to be cured, which is multi-tiered clauses. My question, Fernando, and I would ask you to take the lead on this, is do we really need multi-tiered clauses? If we want them, what should we consider and what should we avoid? And we have a few interesting examples on the screen that I'd ask you to take the lead on.
First one is a typical example of clause where parties have the intention to try to avoid a dispute through some kind of negotiation. It's not clear. We can say that it is an ill-drafted multi-tiered dispute resolution clause. The clause does not provide a proceeding to this phase, does not provide a deadline, and does not clarify if the phase of settlement is mandatory or not. This kind of pathology offers to the defendant the ground to argue that the claimant did not comply to pre-arbitration procedure requirements, and there are a lot of different decisions in many jurisdictions about the enforceability of the pre-arbitration requirements. Arbitral tribunals generally are inclined to excuse the non-compliance of this kind of provision, but when this matter is presented to a court, there is more inconsistency in the decisions. I think we have to stimulate parties to avoid disputes, of course, but I dare to say that the pre-arbitration procedure requirements cannot be seen as mandatory. This is the called agreement to agree. And this issue cannot be an obstacle to reach the arbitration. Otherwise, the initial good intention of the parties to avoid the dispute will become a way to avoid the solution. So I think it cannot be mandatory, never. It's about the first one. I don't know if you want to proceed or.
No, you can proceed, and maybe afterwards Gary and Eliane can pick up on any specific issue.
The second one, the parties shall mediate so long as one party believes settlement through mediation is possible. Oh my God, this is an oh my God clause. It's a schizophrenic clause. I don't know. Of course, it's not reasonable. Obviously, one of the parties will eventually file an arbitration request, but the other party will spend a long time discussing its right to keep believing in a mediation until the end of the world. I know lawyers that are able to take this issue to eternity. So I think that the comments I did about the last clause are applicable to this one too. And the next one, prior to any judicial proceedings, parties shall submit their disputes to an arbitral tribunal of 3 members. And at the end there, if any conciliation is possible on the enforcement of the contract, only the commercial tribunal of Versailles shall be competent. I made a very brief research about this clause with the support of my colleague in the office, Ana Catarina Scheffer, and I found out that when you have a dispute and it's lower than 5,000 euros, no appeal can be filed against the decisions made by a French commercial tribunal. It's something that I didn't know. It's very interesting to know that. Anyway, I dare to say that maybe, and only maybe, parties have chosen arbitration to settle the disputes. And the commercial tribunal of Versailles is competent to enforce the contract and or to enforce an arbitral award arising from the dispute. And once the parties are before the commercial tribunal to enforce the contract or the arbitral award, if any conciliation is possible, the court is competent to make it. This is my interpretation. I don't know if I'm right or not. There are many arbitral and judicial decisions making similar interpretation of the clauses like this one. So I'm not alone in this interpretation. We have many others, but I think that we have to pass to.
Yeah, sure. I'll maybe pass the floor to Gary now. Do you have any comments on any of these clauses that you'd like to add?
Just very briefly, it's often said that the path to hell is paved with good intentions, and I think that's true of multi-tier dispute resolution provisions. The obvious good intention is that parties would rather resolve through settlement after amicable negotiations, resolve through mediation or conciliation their dispute without the cost and expense of an arbitration. That's perfectly understandable, and that's why they include multi-tier dispute resolution provisions. Unfortunately, these kinds of provisions can introduce a host of procedural difficulties and issues. Fernando has alluded to a number of them, but is the obligation to negotiate or to conciliate a binding agreement? If so, what are the requirements with respect to the timing of it? If one, in fact, gun jumps, starts an arbitration before negotiating or negotiating for a specified time period or before mediating in good faith, what is the consequence? Does the arbitration clause become invalid? Was it not really in existence because you hadn't completed the precondition to arbitrate? Most national courts in the last years have been moving in the direction of treating these as procedural issues, which are subject to the arbitral tribunal's general procedural discretion, and thus not jurisdictional defects in either the arbitration or the ultimate arbitral award. But nonetheless, one sees outlier decisions and awards after perfectly good arbitrations get annulled or denied recognition because a party allegedly hasn't fully exhausted the obligation to conciliate or to mediate.
Eliane, would you like to make any particular comment on any of these clauses or in general before we move to the next topic? I think you're on mute, Eliane.
Sorry. Just briefly, just a general comment here. It is quite common that we receive clients saying that they want to start arbitration immediately, even if this means to ignore the pre-arbitral steps. I think it's quite common for you as well. And sometimes we have to say to them that the non-compliance of the multi-tiered clause can be understood as a mandatory condition for the arbitration, because if it is not complied by the parties, the arbitration will not start, or can be interrupted, or can be in the future considered null and void. And sometimes the non-compliance with these pre-arbitral steps can be considered just a simple failure to comply with other clauses of the contract. And then it can bring in the arbitration some penalties related to the breach of the contract. And then it seems to me that the lawyer will be essential in the decision of what to do if they have a defect clause like this one that we are seeing here. In most cases, when a clause is vague like this, we have to exchange notifications informing about the existence of the claim, requesting meetings, negotiations between the parties. And this will be really important in the future, and to safeguard the integrity of the arbitration award afterwards. I think those were my final comments in relation to this clause here. The other one, it seems to me the never-ending story, but I think you already comment a lot about that.
Eliane, my final comment before moving on to the next topic is that I tend to advise clients when we're still at the drafting stage and they come with these multi-tiered mechanisms. Listen, do you really need this? Because you're free to negotiate, conciliate, mediate at any point in time, and you don't have to have a binding clause to allow you to do that. So keep it, as Gary said, it's one of my favorite principles, the KISS principle. Keep it simple and stupid, and let's not innovate too much. It's always the best way to go. Well, with that said, and we'll move on to I just wanted to bring to your attention, for everybody who's watching, we may have a little time before the end of our session for questions from whoever's watching. So if you want to put any questions, just write it into the chat for any of the speakers, obviously. And with that said, I'll move on to the last topic that we have selected for today. It's very relevant, many times not discussed, which relates to the law applicable to the arbitration agreement. And I would love, in first place, to hear Gary's views on this topic. So what happens when the parties have not indicated the law that applies to the arbitration agreement? That's an easy one, Gary, for you. Please go ahead.
Thanks so much, Sophia. It's of course not a hypothetical or an unusual circumstance. Parties very frequently do not include the law applicable to their arbitration agreement in either that agreement or their contract generally. Parties very frequently, of course, do include what I would call a general choice of law clause, a clause that provides this contract shall be governed by the law of Brazil or some other jurisdiction, but very seldom do they provide that this arbitration agreement shall be governed by either Brazilian or some other law. We all know, of course, that by virtue of the separability presumption, the arbitration agreement is a separate contract, a separate agreement, and therefore, at least arguably, the party's choice of the law governing their commercial contract, the underlying contract, doesn't extend to the agreement to arbitrate. And that therefore raises the question, and I think this is what Sophia's question poses, raises the question of, well, what law does apply to the arbitration agreement? Before I answer that question, the failure to choose the law governing the arbitration agreement doesn't in any way render that agreement invalid or pathological. as I said, most arbitration agreements don't have a specific and express choice of law with respect to the agreement to arbitrate, and the absence of that choice doesn't undermine the validity of the agreement to arbitrate. That said, it does create questions about what law applies to the arbitration agreement, and there is a real diversity of views with respect to that question. English courts, other courts have very recently issued judgments on this. The Enka versus Chubb judgment by the UK Supreme Court is a good example. My own personal view, putting aside what national courts have said, is that the proper conclusion is that the party's choice of the arbitral seat should be regarded as an implied choice of law with respect to the arbitration agreement. The arbitration agreement has by far its closest connection with the arbitral seat, as opposed to the law governing the underlying contract, the commercial contract. And one should consider the party's choice of the place of the seat of the arbitration as a choice of the law governing the arbitration agreement. That said, the UK Supreme Court seems to have adopted a different view in Enka, and concluded that a choice of law clause, a general choice of law clause, will ordinarily be interpreted to extend to the arbitration agreement, notwithstanding its separable character. The court also interestingly adopted the so-called, or appeared to adopt the so-called validation principle, pursuant to which the validity of the arbitration agreement will be upheld under any applicable law that might reasonably be applied to the arbitration agreement, meaning either the law of the arbitral seat or that of the underlying contract. My own view is, as I mentioned previously, the better approach is to apply the law of the arbitral seat, although I think there is considerable force to a validation principle.
Eliane, Fernando, I don't know if you want to add anything on this topic. Have you come across this discussion in any case that you've handled, or is there any other comment that you'd like to make?
No, Sofia, just a small remark that this case here is the SulAmérica case. He's quite famous here in Brazil. And we know that they had a lot of lawsuits here and a lot of lawsuits in the UK. And then at the end, I think that they settled and dropped all the actions filed here in Brazil and continue the lawsuits in London. This is just curiosity about this case.
Okay, thank you, Eliane. Fernando, would you like to add something?
No, I cannot comment this clause.
Okay, well, just maybe a follow-up question for you, Gary. In your opinion, do you think that when drafting arbitration clauses, well, typically when we see institutional recommendations or even the IBA guidelines on drafting arbitration clauses, which, by the way, I suggest that everyone who's listening read, because they're a very useful instrument, we don't typically see the issue of the law applicable to the arbitration agreement as one of the optional requirements to include in the clause, and most certainly not as one of the mandatory elements to include in the clause. Would your advice be for parties drafting arbitration agreements to include a reference to the law applicable to the arbitration agreement?
I think that's a difficult question. Historically, my advice was not to, in part because of the validation principle, which interestingly was applied, albeit not explicitly, in the SulAmérica case. The English court, because of doubts about the validity of the clause under Brazilian law, concluded that it was subject to English law, which upheld the validity of the clause. Historically, I took the view that specifying the law of the arbitration agreement wasn't desirable because it interfered with application of the validation principle, that it arguably would exclude application of a law that would give effect to the arbitration agreement. I have to say that with Enka versus Chubb and similar decisions in Singapore and elsewhere, which seem to push in the direction of subjecting the arbitration agreement to the law governing the underlying contract. I have to say I'm moving in the direction of including a provision in the arbitration agreement specifying the law of the arbitral seat as applying to that agreement, to the arbitration agreement. I worry that application of the law governing the underlying contract often produces undesirable consequences when that's a different law from that of the arbitral seat. And notwithstanding the possibility of sort of avoiding or interfering with application of a validation principle, I'm moving in the direction of including a provision that specifies the law governing the arbitration agreement specifically. I think it's an issue that warrants consideration on a case-by-case basis, though.
Complex international contracts, I would expect. So we'll have to wait for Gary's 4th edition to see what his position is going to be, but we have a good indication here. I don't know if we have any questions meanwhile from the people who are watching us. I think not. We have, and I thank the audience for their kind words, congratulating the panel. I would also like to thank the 3 panel members for their great comments on each of the topics. It was a pleasure for me to be able to moderate this panel. I think we managed to cover most of the relevant topics that usually surface. And I really do hope that the audience enjoyed themselves. And I don't know if I'll maybe just give a minute or two to each of the participants if they want to close. And after that, I'd pass the floor to Lauro to close the event. So maybe ladies first. Eliane, do you want some famous last words today?
No, I just want to thank you, Sofia, for your moderation. It was great and a pleasure to be with you here. Thank you.
Thanks, Eliane. Fernando, would you like to add anything?
Thank you very much, Sofia, for the moderation. Thank you, Laura, for the invitation. And Gary, it was a pleasure to be here with you and learn from you. And Eliane, it's a good and old friend, not old in the sense of age, of course, but it's very nice to be here with you, and hope to catch up personally sometime, maybe after this crazy times that we are living right now.
I have a hearing in Brazil at the end of the year. Hopefully I'll be able to go there. Fingers crossed.
Let's
Gary.
Let's drink some wine.
Exactly. Gary, a few last words today.
Just very briefly, thank you very much, Sofia, for the invitation, for the excellent moderation and provocative questions. Fernando, Eliane, it was a pleasure, a privilege, and honor to be on this with you today. I hope the audience enjoyed it and your comments as much as I did. Thank you.
Thank you very much to the 3 of you once again. And Lauro, I think that covers it from our side for today. So I would turn over to you for any closing remarks you may have.
Okay. Sofia, thank you so much. Gary, Fernando, Eliane, thank you so much. I would like to thank our sponsors and the arbitration channel sponsors also. So I hope to see you in our next events. Okay. Thank you. Bye-bye. Be safe.